Welcome to this meeting is being live streamed. Whitney, you got to take the.
Sorry.
It's showing the Zoom box. There we go. This is the House Judiciary Committee now. It is on Friday, the 8th. It's a voting session. And we're going to vote on some things. So let's go ahead and look at, to begin, House Bill 123. This did not go to subcommittee, I don't believe. Correct, Claire?
That's correct.
Okay. It's an administration bill. I don't believe that there are amendments.
No.
Okay. Claire, could you explain the bill? You could use, yeah.
This is a departmental bill and it alters the definition of earned compliance credit to exclude monthly supervision fees in order to allow an individual under the supervision of the Division of Parole and Probation to accrue earned compliance credit to reduce the period of active supervision of the individual without the individual being current on the payment of the supervision fee.
There's a favorable and a second discussion, Delegate Moon, then Valentine.
Is this the same issue that we just heard from Delegate Embry? No. Okay,
It's similar.
okay. Sorry, and is this not a scenario where it's appropriate to remove this fee? Likewise? Like, is it the same problem in the same posture that's being handled in a different
I think
manner?
the probation fee as opposed to a parole fee. The parole fee was what her bill
This might be
dealt with.
both, but.
This is a probation fee
Certainly.
and it's different.
But I guess the question is the same. Do we want to handle these in the same manner?
I think this could apply to probation.
Yeah.
It could apply to both.
Yes.
So in other words, well, okay, so for the purposes of
Yeah.
this bill,
It's probation, parole, and mandatory supervision.
it's all three. So it's probation. So the point here is it doesn't,
If we didn't charge the fee, we wouldn't have this problem. And in another bill, it sounds like we might get rid of the fee.
so I would say in the case of the parole fees generally charged to somebody who's been held for a much longer period of time. And the money goes to the general fund. I'm not sure that probation fees go to the same place as the parole fees do. But we can ask more questions if you'd like, if you want to hold on to it and see if you want to do something
Whose bill
else.
is this?
But
It's the department's bill.
yeah,
Do you mind?
Yeah.
Do you mind if I'll use a hold?
Oh.
You wanna hold? All right.
Oh.
I'm using it against the governor. Just kidding. Just kidding.
Okay. Everybody get that at home? Miles isn't here, is he? All right, there you go. He's gonna hold it. Do you mind deferring your question or do you want to ask a question now? It's up to you.
If you don't mind,
Yeah.
just the suspension of fees, is that a permanent suspension or is that just that these? I was trying to understand the wording on it where they would just be during a certain period of time. Is it an indefinite suspension of fees?
It doesn't do away with the fee.
Fees, at some point they would have to catch up.
Yes,
Is-
sometimes they would have to catch up. All it's saying that is if you were on probation, you're getting credits for the length of time that you're on probation and that you're doing it well.
Mhm.
And so it doesn't matter. So what this would say is it doesn't matter if you were able to pay the fees so that you got good time credit effectively against your probation.
Okay, so,
Right.
but it doesn't eliminate the responsibility of the fee.
Right.
That was my question. Thank you.
So we're holding it anyway, so we'll be back to this issue momentarily. Probably, who knows? 274. Okay, 274, Delegate Simpson's bill. Like a phoenix rising from the ashes. There's a favorable and a second and discussion. On 274, there's a favorable. Seeing none, the vice chair.
Yes.
Yes, Munoz.
No.
No, Crutchfield.
Yes.
Yes, Carden. Yes, Sample Hughes is excused. Embry. Yes, Pasteur. Yes, Tolles. Yes. Oh, Schmidt. No. Simmons. Yes. Boucher. No. Phillips. Yes. Roberson. Yes. Tomlinson is here. No. I wasn't sure. I just hadn't looked over there in a second. Erican. No. Taylor. Yes. Simpson. Are you sure? Yes.
That didn't sound popular.
Grammer. Grammer votes yes. Moon. Yes. Valentine. No. Conaway. Yes. Kaufman.
Yes.
Yes. Williams.
Yes.
Favorable motion is adopted. Oh, this is about that. Sort of in the same part of the hymnal, House Bill 290. There is an amendment. And this went to who? Did this go to someone? Public Safety? So this was Delegate Williams. So there's an amendment that seems to add second-degree assaults.
Yes.
Claire, would you tell us what the amendment does? And what the bill does as amended?
The amendment adds second-degree assault as an applicable crime. And the bill creates an exception under the Wiretap Act to make it lawful for a person to intercept an electronic communication if the person has a good faith belief that they or another person are in imminent danger of becoming the victim of certain crimes, including a crime of violence, stalking, abuse, as defined in the protective order statute, a violation of a protective order, or with the amendment, second-degree assault.
Yes.
All right, so first, there's an amendment.
Move the amendment.
It's a motion for the
Second.
amendment of the second, so we're on the amendment to add second-degree assault. Delegate Munoz.
Thank you, Mr. Chair. My question is about this amendment. So originally, this bill had to do with just domestic violence situations, and now are we adding second-degree assault for absolutely everything and every individual in every possible circumstance?
Yeah. That's what the amendment would do.
So if someone started a bar fight and then someone else hit record and the person responded to the initial assault, that recording would then be admissible. Does that make sense? Like someone instigates a fight, then someone presses record and the response is then admissible as a second-degree assault.
It's inadmissible, or are you saying it's?
It's admissible
It is admissible.
under this new amendment.
The public safety. But it was, if all that happened between.
But wait a second, you get to turn on your mic. If you're gonna explain, you get to turn on your, go ahead.
I just wanted to point out that if it took place in public and you had an expectation, you didn't have an expectation of privacy,
Mhm,
then that would be admissible anyway. But if it happened in private,
mhm.
then you're right.
So if, like
The audio.
hypothetically, like a gang situation, someone instigated a fight in a private place, then someone was waiting to press record and they recorded the audio and visual of the retaliation, that piece alone would then be admissible without the first piece. and it has nothing to do with domestic violence.
And so.
Yeah, Delegate Williams.
So part of the rationale behind the amendment, it was something that was offered, I think it was a request from the Family Law section of the Maryland Bar Association, as well as the Women's Law Center, as well as the Maryland Network Against Domestic Violence. Because sometimes, even though it is a domestic violence situation, initially, it's not always recognized as such when the call is made. And so that was why there was the request to add in the assault, because sometimes it's not, even though it may be domestic violence, sometimes it's not always recognized or even reported initially as domestic violence. But I understand your point, but yes.
And so then the ACLU of Maryland was initially came in opposed to this bill. And so are they still opposed with the amendment?
As the ACLU?
Was opposed to this bill initially. And so are they now still opposed with this amendment?
I'm not certain if they're still opposed or not. But the majority of second assault cases typically are domestic violence matters.
I suspect they would continue to
Oh,
be
the reverse.
opposed.
Most domestic violence cases, I'm sorry, are second degree assault. Sorry.
Delegate Pasture, then I see others.
So I'm confused going along with Delegate Munoz. So if we're talking domestic violence, so I am hit and someone then turns on the video, the recorder, and I hit the person back in trying to defend myself, then someone can edit that? Or what?
Whether or not that audio would be admissible in that case.
But my question is suppose the audio, I'm not even worried, I mean, because words are gonna come out with both blows probably, but it just seems to me that how do you ensure that what started it, what precipitated it is going to be used and be admissible? How do you do that as opposed to what the response was?
Let me do this. Let's walk this back a step, because I think that's, I mean, fundamentally what this is doing is it's carving an exception to the existing two-party consent statute, right? Correct, Claire? I'm getting that right? So.
Which we just moved to a misdemeanor.
Which we.
Currently it's a felon.
Currently is a felony, but Delegate Simpson's bill that we just voted for would make it a misdemeanor. And the two-party consent rule says you need to have both parties' consent in order to, but I think it's important to kind of walk it through that way. So you have to have both parties' consent to record them. If not, it's a crime unless you're in a situation where it's in a public space, as Delegate Embry was talking about a moment ago. So I'm trying to think about the situation where you'd have a second degree assault where somebody's assaulting somebody else and there is a recording, somebody's recording it.
This is used by the person itself. This can be used by.
But it can be used for the person itself?
Yeah, this is
All
the
right.
main thing, like if I think my husband's gonna hit me, I can press play.
All right, that's, okay, that's starting to make sense, but the vice chair is very anxious and then we're gonna go over you.
Let me in,
And I
coach,
see-
let me in.
Yeah.
So the bill speaks to abuse under 4-501 family law. And abuse includes assault in any degree. So if we want to help victims of domestic violence, then wouldn't we do that through abuse and not need to say second degree assault? Because if we go to second degree assault, then we do get the situation that Delegate Munoz was talking about, or the whole universe.
Delegate
It was good
Moon,
before.
then Grammer, then Embry. Delegate Moon.
So just to clarify I have a question. It's about the privacy interest here. So if it happens in public, obviously there's no expectation of privacy. If it happens in front of a third party that's taping, that's otherwise not a public place, I assume there's also not an expectation of privacy because you did it in front of a witness. And so the tape verifying what the witness is saying can be entered into evidence currently. And
It
now,
would be a crime to have made the tape in the first place. That's what this bill is going to.
well, here's the scenario I'm thinking of. This is like someone with a nanny cam or something like this, that's been someone who incidentally is taping something, and now you can bring it into court because it caught that you were being assaulted at the time. That seems to be a narrow use case here. But otherwise, I am wondering if I'm wondering the right question, which is, when is there going to be a surreptitious recording of me being assaulted? Is that correct, what we're doing here?
On the point that I think is what they're going for here is, you have a camera that is just in the room when the act of domestic violence happens and when person A pushes person B. That otherwise would be, you'd need to have consent because they're not in public. It's not anything where they'd have the right to do it anyway. So this would be in those scenarios where it otherwise would be a person A said, person B said situation. Grammer and then Embry and then Munoz.
Thank you, Mr. Chair. So I'm going to emulate my good friend Delegate Moon in thinking about what the Senate's going to do. So we excised this bill for months prior to session. It's been chopped by about 60%. And the only debate that's left here is, to what crimes does the bill apply? Like, we could feel the controversy about that already. So whatever we pass here, the Senate is already telling us will likely not survive. So whatever we do with this amendment, I don't think likely sticks in the Senate. So I do appreciate the work of the subcommittee. I'm going to be a no on this one. Personally, I think this is something we could probably consider in the future. But I just don't think, considering what we're feeling right now, that adding this to the bill helps us get through the Senate.
Just to say that I think the vice chair is right. I don't think we need the amendment, given the definition of abuse and the family law. So whatever.
Thank you, Mr. Chair. And I guess the last thing I'll say is, I do think this bill in its original form was such a good bill. And I think it's really important to protect domestic violence victims. And I'm concerned that with this amendment, we're going to kill the bill. And so that's why I'm going to vote against it.
Hold on one second. So abuse under the family law article, which is what I was looking for, means any act that causes serious bodily harm, an act that places a person eligible for relief in fear of imminent serious bodily harm, assault in any degree, rape or sexual offense, all of which I think would be covered, or sexual offense in any degree. It covers all four, actually, sex offenses, false imprisonment, stalking, and revenge porn. Thank you. So that is the definition of abuse. So I would argue that assault is already covered. I think that's at least how I'm reading it. Am I wrong?
You're right.
No.
It's just that the advocates strongly want second degree.
I mean, I can understand wanting to have second degree assault explicitly put in there, but I also, if it's covered in the definition of abuse, do we really need to? So, okay, we are on the amendments, and there was a second on the amendments. So we're on the amendment. Do you still wanna, you have anything? Your light's still on. Oh, all right. Okay, well, let's see, we'll take a vote. All in favor of adding the amendment that would add second degree assault to the bill, please raise your hands. Okay, one, the subcommittee chair fighting like a tiger. All opposed? All opposed? All right, the amendment is not adopted. We're on the bill. It's just a straight favorable, and there's a favorable and a second. Further discussion on the bill. All right, seeing none, the vice chair.
Aye.
Aye. Munoz.
Yeah.
Yes. Crutchfield.
Yes.
Yes. Carden. Yes. Sample Hughes is excused. Embry. Yes. Pasteur. Yes. Tolles. Sorry? It's fine. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Moon. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams. All right. Okay. That is a straight favorable now. So those go over here. Questionable sponsor in House Bill 315, the vice chair's bill. All right, there's an amendment. Is there an amendment? Said there was an amendment. Because this is how we're dealing with fiscal note, right?
Right.
Who wants to talk about the amendment? Holly, vice chair?
It's just, so the amendment simply moves the requirement on the reporting to judiciary.
It was my understanding the judiciary said that they could handle this with existing resources.
That is correct, Mr. Chair,
All right,
and everyone's
so
happy.
motion and a second on the amendment. Any further discussion on the amendment? All in favor, rate, oh wait, sorry, lots of questions. Tolles, Delegate Toll.
Thank you, Mr. Chair. Does the judiciary already do this?
Madam Vice Chair.
They do not already do this. They obtain some of the data, but they don't do it in the sense that of what we're asking them to do, and that is to catch all of it and report it back to us. They do a regular reporting.
And I'm sorry, I should rephrase my question. Yeah, do they do reporting? Not
Yes.
some-
Oh, yes, every year. They do reporting.
Okay.
Mhm.
So they're not new to reporting and they won't come back next year and be like, we need more money.
Oh, no, they do it. They already do it and they already obtain the data.
Okay,
All right,
thank you.
any other discussion on the amendment? Delegate Williams.
Oh, I was just gonna add, Mr. Chair, that I had in my notes that the judiciary testified that they were supportive of the bill with the amendment.
Okay. Somebody has a bingo? Everyone hold on to your cards. Please don't, oh, sorry, that's different. All right, seeing no other, no other questions, all in favor of the amendment, please raise your hands. Yes. Anybody opposed? Amendment's adopted. We're on the bill as amended. Motion for a favorable. Is there a second? Motion for favorable and a second. Any further discussion on the bill as amended? If not, the vice chair.
Yes.
Yes. Munoz. Yes. Crutchfield. Yes. Carden. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Moon. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams. Yes. Favorable is adopted. Off we go to Delegate Long's bill. There's a motion for a favorable and a second. There are no amendments. Never mind, there are amendments, so we can't do that yet. We have an amendment. But do we have an amendment? Because I don't see an amendment. Oh, wait. Yes, we do. So the amendment, is this Cardin's?
I combined them, there are two.
Why don't you tell us what the amendments do?
It was sent in your packet. So we have an amendment from Delegate Cardin, which makes the bill prospective in nature. And then the amendment from the bankers and the Maryland Judiciary, which is supported by the sponsor. Instead of authorize or requiring, it strikes requiring and substitutes authorizing. And that is, it authorizes an automatic stay of civil actions and proceedings when a petition is filed versus requiring. And this was per the bankers and Maryland Judiciary's request.
Move favorable on the amendment, Mr. Chairman.
Second.
Favorable in a second. Discussion on the amendments. The Vice Chair?
So how, it seems like it kind of changes the principle behind the bill. In the sense that now it authorizes, so it's at the discretion as opposed to the requirement.
Delegate Card?
Yes.
So, but is that okay, so here's my thing. Is that a good thing?
So the issue was that there could be unforeseen or unknown circumstances that needs to get before a judge before the stay can be, there could be other evidentiary information that would be pertinent. So what this does is this basically requires the judge to see it, and assuming that everything is in order, everybody believes the judge is going to grant the stay. And it's going to be done expeditiously, which is the intent of the sponsor.
Oh, the expediency. Okay, thank you.
Does that
That does, yeah.
Anybody else with questions about the amendment? There, that was moved and seconded. Delegate Taylor,
So I heard us say that
pull your microphone down.
I heard us say that the sponsor was okay with Amendment 1. Was he also okay with Amendment 2?
Yeah.
Okay, great.
He came to the
Yeah.
He came to the subcommittee?
Yeah.
All right. Okay, all in favor of the amendment, please raise your hands. Yes, 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 yes. Anybody opposed? Amendments are adopted. On the bill as amended. There's motion for favorable. Is there a second? Moved and seconded. Any further discussion on the bill as amended? Seeing none. The Vice Chair?
Yes.
Yes. Munoz?
Yes.
Yes. Crutchfield? Yes. Cardin? Yes. Sample Hughes is excused. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? Yes. Kaufman?
Yes.
Yes. Williams?
Yes.
All right. I don't know, everybody. 2 bills for Delegate Simpson? I don't know. House Bill 406 has an amendment. This is Lauren. There's a motion for the amendment. Is there a second?
Second.
All right, now we'll go to discussion on the amendment. What does the amendment do? It appears, it says it adds a former spouse, that this could be a spouse or a former spouse?
Yes.
All right, this went to the subcommittee? Okay, do you want to add more insight, Delegate Crutchfield?
You're absolutely correct. That's what it does, is making sure that both are covered if there's a.
Yeah, you need to-
You're correct. That, trying to make sure that the spouse and a former spouse is covered in the situation where there's a communication regarding a criminal action like this.
So in the end, how would this work? Just to walk it through from the beginning. So now one spouse is not competent to disclose any confidential communication.
Yes.
Oh, I'm sorry. Okay, so this is related to a crime with one spouse against the other
That is correct.
other spouse. So if you had a
Yes.
situation where so they would be outside of the marital privilege at that point.
That is correct.
And so if
And there was
they
an incident that
filed for
happened.
divorce, I guess, is what this amendment would do. If they tried to. Although
And
I
it was
guess
a- and
that
it was
would
a-
be kind of odd. They wouldn't be trying to avoid the marital privilege.
No, no,
with it.
no, right. So it's an incident that happened during the marriage.
Got it.
Okay.
Okay. All right, that makes sense to me. It's a motion, we already, we moved it already. Is there any further discussion on the amendment? Seeing none, all in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 18, 19, 20, 22. Anybody opposed? It's adopted. On the bill as amended. Motion for a favorable in a second. Hit your button. There was a question as to, so now what does
Doing
this
that.
do?
Right. So now it adds in, if there was a situation that happened during the marriage, okay, that now a spouse wants to communicate about, that spouse, even though they are no longer married, that incident happened during the marriage, can now still elaborate on that communication, okay? Couldn't do it before, because it was.
Thank you, Mr. Chairman. So my question is, wouldn't this change the general agreement that the two parties enter into when they get married?
Which, so the general agreement in what way? That they would not
Well, that,
testify against each other in a criminal trial?
yeah,
I mean, I think I'll go to the subcommittee chair, but
Yeah, I mean, yeah, there, in certain instances, we're talking about abuse, we're talking about, we're talking about certain situations. Okay?
you gotta.
Sorry, we're talking about certain situations that occur during the marriage, like abuse, like something more physical, okay?
sure.
And then you leave the marriage
Sure.
and then you can now communicate about that, okay? Because now you're gonna file a charge or now you're gonna do something different. Okay,
Wouldn't you normally file a charge while you were still married and that be part of the proceedings on?
you
not-
can do that both ways.
No, I'm not, if you want to talk to me, I mean, that's fine. I'm trying to. So, you're saying not necessarily?
Right, right.
So currently, can a former spouse file a charge against their ex-spouse after divorce?
Of course they can, but the question is, can you elaborate? Can you communicate about that privileged thing that happened during the marriage? Okay?
And you
Because-
don't believe that that's a violation of the agreement that you entered into when you got married?
I'm not gonna go into that part of it.
Oh, okay.
Okay.
Who should I contact to find out if they can go into that part? We don't use that term in here. Thank you.
You can hold.
We're on House Bill 406. It's that is favorable. There's a motion for a favorable with amendment. Is there further discussion? Okay, the vice chair.
Yes.
Yes, Munoz.
Yes.
Yes, Crutchfield. Yes, Cardin. Yes, Embry. Yes, Pasteur. Yes, Tolles. Yes, Schmidt. Is not, he's excused. Simmons. Yes, Boucher. Yes, Phillips. Yes, Roberson. Yes, Tomlinson. Yes, Erican. Yes, Taylor. Yes, Simpson. Yes, Grammer. Yes, Moon. Yes, Valentine. Yes, Conaway. Yes, Kaufman. Yes, Williams. All right. Next one is a departmental bill. It's House Bill 435. There are no amendments to this, I don't believe, right, Warren? It's a motion for a favorable and a second. The bill as I understand it, it addresses people who are under child support obligations when they're incarcerated. They can't be considered to be voluntarily impoverished. Is that that's the crux of the bill? Can you get? It brings us into compliance with federal law. Yeah. So if you're being held in jail, you can't go to court and say, well, they're voluntarily they're voluntarily impoverishing themselves because they're in jail. So yes, they're impoverished. Delegate Ayercan.
Okay, I just have to say this, and I get that's the federal law thing, but just as a mother, essentially what you're telling mothers is that because the person you had babies with is now in jail, you are probably going to end up getting less money, and that just is the worst, so.
Okay. Is there further discussion on this legislation? All right. Yeah, Delegate Taylor,
Just-
pull
your microphone down.
Just as a, if you're, if you have the means, right, and you're incarcerated, and it's determined that you still have the means, you would still pay your normal child support, right? Okay. Right.
You
thank
just, I think part of it is, again, you can't claim, you can't take action against the person that they went to jail in order to voluntarily impoverish themselves.
Yeah.
They can still get the money from other places.
Thank you.
All right. Seeing no further discussion, the Vice Chair.
Yes.
Yes. Munoz.
Yes.
Yes. Crutchfield. Yes. Cardin. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. Yes. Erican. No. Taylor. Yes. Simpson. Yes. Grammer. No. Moon. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams. Yes. It's adopted. Okay. 585. It's a speaker's bill on protecting election workers. There is an amendment.
Second, move is favorable.
So we sent this to subcommittee, correct? Did this go? Clearly didn't go to Delegate Moon's subcommittee. He's not jumping up and down. So I'm looking. Did we send this to subcommittee? Okay, this went to public safety. Okay, so I see one amendment from Delegate Erican. That's not it.
No, it's audited. This is audited from the. Sorry.
Okay, so there are two amendments. Or is there? Okay, so here's what I've got. I see two amendments. One of them was drafted by Delegate Erican. That's
not one of
I've got that. So I'm just gonna say Delegate Erican, I'm gonna look at the subcommittee's amendment first, and then I'm gonna come to you. So that the subcommittee's amendment is 503424. And can you talk about what that does, please?
Yes. The amendment that came out of the subcommittee was just adding in the local councils to the local board of elections, who are also assistant attorney generals, and assist the state and local boards. And so just protecting them as well with the other local board and state board officials.
Did we get this in?
Are there questions? Let's do this. Can I have a motion on the subcommittee's amendments? Motion and a second. All right, so we're on discussion now on that amendment. Delegate Erican.
Sorry, you said county council members? Oh.
This is for the council, the attorneys.
Oh, council, with spelled differently. Got it. Okay, thanks.
So this adds the council to the state board to, a council to the state or a local board of elections to the list of people that you can't threaten. Wait, no. Right, that, so that you can't, threaten, harm, make a threat to harm an elected official. Do not threaten the attorneys as well. All right.
In general.
I mean, this committee is generally for that. All right. Further discussion of the amendment, Delegate Carden.
Everybody's compensated, right? There's not a question of people who are uncompensated that are also included in this. Because that was something that came up, right?
Included with the amendment would be the state administrator, a member of the state board, an employee of the state board, a county election director, a member of a local board, an employee of a local board, an election judge, and counsel to a local board or counsel to the state board. So they all would be compensated in some way, shape, or form.
Great.
Just being candid, I believe that the Senate's bill is different for what it's worth than what I think we ultimately are going to end up with. So we'll see how this. All right, everybody get your whistles out. That's fine. So we'll see how this actually ends up at the end of the play.
Well,
All right.
that begs the question.
Here comes Madam Vice Chair.
Begs the question, what does the Senate bill look like?
We had, it includes pages.
Oh, that's the one.
I believe the Senate bill includes pages.
And
And
so
anyone who takes an oath, which would go beyond people who are paid to people who are unpaid.
I do remember the conversation that we had in subcommittee about the Senate amendments. And I think at that time, we were a little unclear about what a page is under the Board of Elections. I did a little
have it here.
consulting with some of our friends down the hall in Ways and Means. And apparently the Board of Elections has a page program, just like we have a page program here in the Maryland General Assembly that includes 16 and 17-year-olds that will volunteer to help out with the Board of Elections so they can learn more and become more civically engaged. And so that was the reasoning behind, I think, the Senate amendments.
We're on the amendment from the subcommittee, so let's just do that first. All in favor of the subcommittee from the amendment for the subcommittee, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 20, 21. Anybody opposed? Seeing none, that amendment is adopted. Now we have an amendment from Delegate Erican. And let's find out what that does, Delegate Erican.
It's super simple. It just lowers the penalty. I just thought up to 3 years seemed a little extreme, so I put it at 6 months instead. Huh? Yeah, you got it. It was in there. I emailed it to you. I know you never heard me say that about a penalty. You're getting tickled right now. Okay. That's what it is. It's real simple. I just thought it was a little aggressive, especially since there's some stuff in the actual bill, that's a little bit amorphous, like, the emotional side of threatening people. It's a little bit squishy for me.
All right,
That shouldn't shock you.
All right, so the purpose of this bill is to deal with threats that our local election officials have been facing. And granted, it might not have been as egregious here in Maryland as it has been in some other states across the country, but we're going to say that someone who has an oral threat, a threat made against them by electronic communication, a threat in any written form for doing their job, that person, if found guilty, is subject to imprisonment of only 6 months, which in reality, I don't even know what that equals to in reality, like a day and some change. I don't even know.
Yeah, correct. You read it correctly. And my hang up with the bill in general is really around the 4.2 serious emotional distress. I think in my mind, I can't rectify someone causing serious emotional distress to somebody else getting up to 3 years in prison. I think it's a little bit nutty. So that's where we're at.
Yeah, I was gonna save this to talk on the bill, but I think it's pretty germane here. And I think this might be the worst drafted bill that I've seen in my time on this committee. Let me make a comparison. So the fiscal note refers to criminal law section 3708, which is threats to public officials. The germane question here is, what is a threat? Let me read you 3708 of the criminal law article. A person may not knowingly and willfully make a threat to take the life of, kidnap, or cause physical injury to a state official, a local official, a deputy state's attorney, an assistant state's attorney, or an assistant public defender. So if a person was to threaten one of us, that's a pretty high bar for an elected official for 3 years or $2,500, which is the same exact penalty in this bill. Here's the language of this bill. A person may not knowingly and willfully make a threat to harm an election official or an immediate family member of an election official because of the election official's role in administering the election process. So the word threat, what that includes, the only definition we have here is harm, which is serious injury and serious emotional distress. Like, this committee sometimes gives me serious emotional distress. So, and it's, you can get 3 years for annoying an elections official, but you have to kidnap an elected official to get. So I can't reconcile this. And I thought I was content with just voting against bringing it up and voting against the bill, but the penalty is just ridiculous. So, I think it's germane to bring this point up. 6 months is probably a more appropriate penalty for this bill.
So, do you have a question? Go and ask your question. We're on discussion on the bill.
I have a question because I couldn't look it up fast enough. What is the penalty for assault?
10 years.
So it's 10 years for an assault, just a regular assault.
Yes.
And here we're only talking about 3 years. So you can if you threaten someone who is an election judge, no, you don't get an additional.
I don't think it's an additional 3 years, no.
You get the 3 years. Well, they would probably charge the assault as opposed to the under this.
You might get charged with both. I mean,
Okay.
so there's fun in law school. So there's a battery, which is me actually touching somebody else, and then there's an assault, which is not. People think of assault as being that contact. It's not. It's putting somebody in imminent fear of an unwanted physical touching. And so the harm that's in the bill, I mean, it would include, it could potentially include an assault. Delegate Grammer's slide is still on.
Yeah, if I was an attorney, I would look at this and just be like, what is serious injury? What is serious emotional distress? It's just not a well-written bill. And I talked to the folks lobbying for the bill. I'm not necessarily opposed to the bill, but I just feel like if we want to do this, it should look better coming out of the committee, because it's a bit of a mess right now, especially comparing it to a current law we have, which applies to election officials, and the bar is radically higher. I just think this should be worked out better.
I guess my question is actually for Delegate Grammer. What is it about the writing or about the bill that you find to be particularly poorly written?
If you look at 3708, it defines local official, it defines threat, and threat includes an oral threat, a written threat, and the specific actions under the crime in question. Here it's parent, spouse, and child, but like harm, you're including anything that's serious injury or serious emotional distress. Like, what serious emotional distress is a pretty wide range in 2024, is a pretty wide net for anything. I mean, this could be an online threat. And the bill explicitly says things people could say on Facebook or Twitter or whatever, and we all know how that goes. So if someone says something on Twitter and it causes an election official serious emotional distress, now they're up for 3 years. Like, this bill is, I get the premise of the bill. I'm not opposed to the premise of the bill, but this is just one of the most loose bills I've ever seen that we're going to stick in criminal law here. And when we compare it to an almost identical bill that applies to election officials, how would you explain this to a constituent? Like, it's so radically lopsided. I just think we ought to, if the threat, we should just hash out this threat section so it's much clearer what we want to deal with here.
I guess my question to Delegate Grammer is this is a threat to do harm, not necessarily that the harm actually occurs. So what's your issue? I mean, I mean, it's a threat. That's kind of the point. Delegate Cardin?
I'll just say, I'm just gonna say, give my opinion. I think that and you know my opinion about cyberbullying generally, but if you go online and you say, this, election administrator really screwed the pooch and she deserves to be, she deserves to be, kicked out of office, not just in terms of her, or kicked out of her position, not just in terms of her, losing her job, but she should really be kicked out, like completely kicked out with a foot. Like, yeah.
Here's the crime. I'm going to go down there and give Delegate Cardin a piece of my mind and tell him he's a terrible delegate. That's a threat to cause serious emotional distress. That is a straight up.
That's not against the law.
Under this bill, it is.
No.
Oh yeah.
Not against an elected official, only against election officials.
Correct. I'm giving you.
There's a difference between saying that about an elected official who puts themselves out there as somebody who's in elected office.
I'm going to go down there and give election official Cardin a piece of my mind and tell him he did the worst job
I get it
I've ever
every day,
seen.
and that's perfectly fine.
That's a crime under this bill.
That is different than saying that about somebody whose job it is to run these elections. Thank you.
It's really going to piggyback on what Delegate Cardin was saying. I think there is a difference. I mean, we purposely put ourselves in this position. We know we're going to get criticism from people in general for the positions that we take. That's the job that we signed up for. I didn't sign up to be a clerk in a board of elections because that was the only job that I could get, to simply transfer the paperwork every time an election season starts, to take crap from people about their political views and political viewpoints. That's what
it's broader than that. It's a threat to do something that could cause someone emotional harm. It's like you're not even doing it.
And we all get threats, and I've gotten threats.
There's a difference between.
But I signed up for those threats. These individuals did not.
I get that. My distinction is that there's a threat and there's a threat. Like if you go online and say I might do something or I ought to do something, I ought to go tell them something. I ought to tell this election
It's going
judge.
to be fact specific. Something that might not offend me may offend you. It's going to be fact specific. All of this has to go in front of a judge.
So, I think emotional harm, right? It is unclear. But is there somewhere in other places in our statutes where we use emotional harm and it's there? Okay.
Yes.
Okay.
That was a common language.
Okay.
Decision is going to be made by the trier of fact. Whether you have a judge or a jury, they're going to determine whether that particular individual actually did suffer emotional harm.
May I add emotional harm to what they do to us?
Right.
Can we add that to the statute?
I think.
It'll go to rules.
Yeah.
Delegate Phillips.
Well, one of the points was already made by Delegate Williams. The other is, it is not to exceed, right? And I think in judiciary, depending upon the level of culpability, they would make that decision. If they're going over 6 months, it's a misdemeanor. I don't think so. So, practicality, I don't think 3 years is too much.
We are on the amendment, so let's deal with this. This is Delegate Erican's amendment again, 653-024. And it would lower the penalty from 3 years to 6 months. So we're gonna vote on this amendment. Yes, Delegate Erican.
Can you just remind me again, what the requirement is when you become a prohibited person? Is it if you've been charged with a crime that could carry up to 2 years or more?
So you're saying that that you would become a prohibited person. The question is whether you become a prohibited person because you had been convicted of a crime, charged with a crime that carries 2 years or more?
Correct.
So you're concerned that people would lose their Second Amendment rights if they
Yes, sir.
threatened an election official and were found guilty?
If they made them have their feelings hurt under serious emotional distress. Yep. Yes, well, I'll just do the absentee voting you all love so much instead. Avoid the whole thing.
Okay,
That's not why y'all have it. Come on now.
no. Let's, so we're on the amendment, I think, and we'll, so, well, I mean, but if the point of the amendment is to get underneath the 2 year standard, I think here, I think the initial argument was that in looking at 3708, and I've been sitting with 3708 threats against a state or local official. We are creating a lower burden for election officials, but I'd agree with Delegate Williams that these are not people who are setting themselves out to run for office or anything else. These are people who are there to unload boxes and in many cases, or call balls and strikes for when they go through all of the ballots. Delegate Williams again.
I was just gonna say, from a procedural standpoint, we already are not in the same posture as the Senate bill anyway right now, so I just wanna throw that out there. The Senate bill still has the 3 years. So there is that. I just wanna remind everyone.
I suspect that
about
we're coming back to this issue.
Right.
So, and I suspect that this discussion is going to probably continue a little bit. All right, we're on the amendment. And we're going to go ahead and vote the amendment. All in favor of the amendment that would lower the penalty from 3 years to 6 months, raise your hands. 1, 2, 3, 4, 5, 6, 7. All those opposed, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. All right, the amendment is not adopted, 7 to 10. We're on the bill as amended with the subcommittee's amendments. There's a motion for a favorable in a second. Now we're on the bill as amended. Is there further discussion on the bill as amended? Seeing none, the vice chair.
Yes.
Yes. Munoz is excused. Crutchfield? Yes. Cardin? Yes. Embry? Yes. Pasteur? Oh boy. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Are you voting yes, Tomlinson? Tomlinson votes yes. Kaufman has to go to a different committee. Kaufman?
Yes.
Yes, thank you. Erican? Taylor? Yes. Simpson? Yes. Grammer? No. Moon? Also gone. Valentine? No. Conaway? Yes. Williams?
Yes.
16. Okay. We're gonna keep trying to do what we can here, but we're losing people right and left here because of bill hearings. Okay. All right. Well, 592.
Favorable.
It's a motion for a favorable. Is there a second? All right.
We need another judge.
Prince George's County wants another judge, apparently. Is there discussion on the favorable on a second? There's favorable in a second? All right. Any discussion? Don't see any. Where did she go? Okay, Delegate Crutchfield. Yeah, it's on 592. Yes. Kaufman is a yes. Carden? Yes. Embry? Yes. Pasteur? Oh my God. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yeah. Valentine? Yes. Conaway? So E? Excused. Williams?
Yes.
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 And the vice chair is yes. Motion is adopted on Prince George's County getting another judge.
I'm just joking.
Suddenly a second thought. 648, Delegate Crutchfield's bill. All right, there is not an amendment. There is an amendment.
Yes.
Great. I don't see the stamp. The stamp's gone. I don't know what to do. Delegate Crutchfield, would you like to tell us what the amendment does? No, I'm good.
Yeah, sure. The amendment just clarifies what non-taxable income, what the gross up will be for non-taxable income. So if you remember, this bill is dealing with just sort of the equity and the fact that you have income for child support, and there are parties who have non-taxable income that's considered versus regular income that's considered, and that the courts do not at this point have discretion to go ahead and gross up that non-taxable income. And so this bill does that, and the amendment clarifies what that would look like for non-taxable gross up, to include, you know, your W-2 information, taxes, et cetera.
Motion on the amendment. Second, we're on discussion on the amendment. Questions and Subcommittee Chair Delegate Graham.
I'm good.
Never mind. Delegate Eric.
Are there any, I know we talked about working for World Bank. Are there any other income sources that came up that people that could be impacted? I'm just trying to get a full picture.
Yeah, sure. World Bank, IMF is
Okay.
one.
Yeah.
So sort of those kind of outside global entities that employ lots of different people from different countries.
Right.
And therefore just provide.
And that's pretty much it.
That's
There's
it.
no other pieces
No.
of income floating out there we're not thinking of.
No.
Okay, all right, thanks.
I was gonna say, give it a chance. Delegate Carden.
The MSBA was favorable with amendments. Is this the amendment that they wanted?
Yes, this is it.
All right.
Maybe.
We've got the amendment. All in favor of the amendment, please raise your hands. 2, 3, 4, 5, 6, 7, 8, 9, 10, 17. Anybody opposed? Amendment's adopted. So now let's go to the bill as amended. We're motion for a favorable and a second. Any discussion on the bill as amended? Seeing none, the vice chair?
Yes.
Yes. Munoz? Sorry, Crutchfield? Yes. Carden? Yes. Embry? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? Yes. Williams?
Yes.
All right, motion is adopted. Okie dokie. Oh my. There's not even an amendment or anything? Allegedly, I quote, never pass, end quote, any bills from Sue McComas. Oh my.
Bye. Second.
Motion for a favorable and a second. As memory, I think this was one that we were told we absolutely had to do or something, which I didn't think is a good reason, but
She did say that.
but it's been the subject of a lot of work with the Family Bar and yes, so they have finally gotten to a good place on this, and that is fine. There's a motion for a favorable and a second with the added benefit of having a bill for Delegate McComas. All right, any questions? Oh, boy. All right, the Vice Chair. Yes. Crutchfield. Yes. Cardin. Yes. Embry. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Moon is not here. Yes. Valentine. Conaway. Yes. And 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 15, 16, 17. It's adopted. Starting to get a little more fun here, everybody. So I don't know. Should we have Delegate McComas defend the bill on the floor? No, we're not doing that. No, we're giving that to you. 854 has an amendment, 854. The Vice Chair's bill on required registration and locations, additional locations to give people places to register. This is Claire's bill. Do you want to describe the amendment, Madam Vice Chair? Great.
Sure. Thank you. So we amended the bill to expand the, to narrow the locations in which the local law enforcement is required to have more places for a sex offender to register. So we now have only for a county, not the municipalities. And so a county with a population of more than 300,000 residents. So that would include Prince George's County, Anne Arundel County, Baltimore City, Howard County, and I believe, actually, I'm not sure about Baltimore County. I'll tell you in just a second on that one, in case you want to know. Ouch. Yes. Oh, I'm getting a pain in my leg. So Baltimore County, okay. And so it would, they would be required to have 2 designated places for sexual offenders to register, as opposed to currently there's only 1 per county. So that's what the amendment does.
Questions about the amendment? Let's do this. Can I have a motion and a second about the amendment? Moved and second on the amendment. All right, discussion, Delegate Erican.
I'm not 100% sure if my question's about the amendment, but I just got a text from my law enforcement and they said it would be incredibly expensive for them to make all their PDs able to register people.
No, that's not what the amendment does. And it would only say that there has to be within 2 locations within the county. There has to be 2 locations where sex offenders can register within the entire county. It doesn't say what, with respect to the police officers and all of them and all of that. It's just 2 locations within the county if your population is greater than 300,000. And I did get, from the chiefs and sheriffs, I did get the green light.
Is that Hartford County too?
I'm gonna look right now.
I think Hartford might not be in it anymore because I think it's just barely too small. Delegate Valentine.
Thank you, Mr. Chair. And I think I have my understanding. So for this purpose, my county in Frederick County, 275,000 people, no changes whatsoever. We have 3 municipals. So the amendment takes care of the municipalities.
Yes.
They're out, 1
Yes.
location, no change.
Yes, that
Thank
is
you.
correct. So I'm looking now. It would include Montgomery, Prince George's, Baltimore County, Anne Arundel County, Baltimore City, and Howard County. I stopped at Howard County. So there we are. Frederick County, Hartford County, Carroll County, Charles County, not included, et cetera, et cetera. Keep going.
On the amendment, all in favor of the amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Anybody opposed? Amendment's adopted. On the bill as amended. Is there a motion? All right, favorable and a second. Any further discussion on the bill as amended? Seeing none, the vice chair.
Yes.
Yes, Crutchfield.
Yes.
Yes, Cardin. Yes, Embry. Yes, Tolles. Yes, Schmidt. Yes, Simmons. Yes, Boucher. Yes, Phillips. Yes, Roberson. Yes, Tomlinson. Yes, Erican. Yes, Taylor. Yes, Simpson. Yes, Grammer. Yes, Moon. Yeah, Valentine. Yes, Conaway. Yes, Williams.
Yes.
Adopted, favorable is adopted. All right. And House Bill 960, a Frederick County delegation bill that is a favorable and a second with a letter from the county and everything. So no amendments. We're on the bill. Are there questions or comments about the bill? All right, the vice chair.
Yes.
Yes, Crutchfield. Yes, Cardin. Yes. Embry. Yes. Tolles. Yes, Schmidt. Yes, Simmons. Yes, Boucher. Yes, Phillips. Yes, Roberson. Yes, Tomlinson. Yes, Erican. Yes, Taylor. Yes, Simpson. Really? Simpson is yes. Grammer, yes. Moon is still not here. Valentine? Yes. Yes. Conaway? Yes. Williams?
Yeah.
All right.
Everybody's ENT.
Everybody's literally a fifth of the committee right now is an ENT. So what are you gonna do? House Bill 1034, there are amendments. Oh, boy. Okay, that's from a different bill. So I see 153923.
It's a big, long amendment from the delegation.
Yeah,
That's it. That's old.
that's not this. That's,
Just one set of big. Reprint, I think.
yeah, it's a big reprint. Hold on a second. I'm just making sure I'm looking at the right thing. Oh, okay, so that's this. Oh, boy, there are all kinds of things in here. Okay, so yes, the amendment is 153923. And I believe it addresses the issue that had to do with whether they can, whether the new people that would be allowed under this bill would have to collectively bargain, if I'm not mistaken. Is that correct?
Summarize the amendments.
Yes, would you please?
Amendment number 1 changes the bill's sponsor to Baltimore City delegation by request of the Baltimore City Sheriff and makes a technical change. And amendment number 2 limits the number of social workers that may be appointed by the sheriff to 2 and subjects the sheriff's authority to appoint any additional sworn or civilian personnel to existing provisions relating to collective bargaining and the provision of funding in the ordinance of estimates or any other source.
All right, the Baltimore City delegation side has approved the amendments, and we are here today on the bill, on the amendments and the bill then in a minute. Can I have a motion on the amendments? It's moved and seconded.
Second.
All in favor of other discussion on the amendments? All, Delegate Arakan.
Sorry, I just want to make sure that there was no opposition to the amendments from like the actual police that are going to be.
So
Bless you.
the FOP, going back to our city delegation meeting, the FOP did initially have some concerns about it, but because they added the language with regard to collective bargaining, that addressed the concerns that they had. Phillips. Delegate.
If I understood what Claire said, it applies only to those individuals that would already be sworn officers in a collective bargaining unit. Does this suggest that they could hire people that are not in a sworn? I guess because the inverse is there are people that may not be, and so they would not be entitled to being in a collective bargaining scenario.
I'm sorry, ask your question again. You
So,
lost me.
I'm trying to make sure I understood what Claire said. This would apply, so if he's appointing these individuals.
Yeah.
It would apply just to those persons who are already sworn officers and already in a collective bargaining unit, or they bring in and that are sworn officers. It may not apply then to, like, let's say like the social workers. I just want to make sure I'm clear on that.
I think it applies to everybody. That was the point that they were making, was that they wanted them all to be under.
Right, and that's what I'm
Right.
just trying to make sure. Does this cover that?
Yeah, I think so, yes.
Okay.
Because that was part of the discussion of the city delegation to address that issue.
Okay.
Yes. Okay, so did we vote the amendment? All in favorable of the second on the amendment, all in favor of the amendment, raise your hands. Okay, anybody opposed? We are on the bill as amended. Any further discussion? Seeing none. The vice chair? Yes. Munoz? Yes. Crutchfield? Yes. Cardin? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Arakan? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Still not here. Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. I'm sorry, he's not here. Williams?
Yes.
Yes. Okay. So I'm gonna take this. Next bill is House Bill 1060. There is an amendment. So the amendment, as I understand it, came from Delegate Rose. This is the amendment that was discussed that I think puts the salary right now at $191,078.10, because we seem to all remember the and 10 cents part. Delegate Boucher.
Yes, thank you, Chairman.
So why don't we do this? So we have the amendment from Delegate Rose. So can I get a motion for that and the second? Okay, Delegate Boucher. Now on discussion on the amendment.
Thank you. When the bill originally came out, it was a set the salary based at the rate of the Lieutenant Colonel of the State Police. The delegation had supported it. During the session, two of the county commissioners that came down, the president of the commissioner board and the past president of the commissioner board, and voiced their concerns about the large salary jump in consideration of the budgetary pressures upon the county. I am very empathetic to this pressure and understanding, haven't been a county commissioner before. So even though this bill says the initial raise will be 191,000, that 191,000, I believe, if you read the language of the bill and the law properly, would only be in effect for 26 days because the sheriff's term would end on December 5th. So his actual raise would be $212,000 once the year switches over to 27 because he is an incumbent. So I think the language of the bill and the amendment is a bit deceptive because he would only be getting $191,000 for a couple of days and the real raise is for $212,000. That was the big concern of the commissioner board, was trying to afford this. So actually the amendment on the bill is making it more expensive for the county to finance the sheriff's wage. I would like for this amendment to die. I would also like the bill to die. I believe it'd be best to handle a wage increase for the next term in the second half of this term. Based upon my experience as a businessman, there's a lot of inflationary pressure. I do not think it'd be wise for us to set the sheriff's salary almost 3 years in advance. I'd prefer to vote on a sheriff's salary increase as it gets closer to the end of the term and have feedback from the commissioner board to determine whether it's feasible to actually put it in their budget or not. I love our sheriff. I think the sheriff deserves a raise. I just don't think it's prudent to put this amendment through and put the bill through under the existing financial stress the county is under. And I don't think it's all hurt the county in any way. I don't think it's all hurt the sheriff in any way. I just say it'd be wise and prudent for us as fiscal conservatives to put this raise off to the second half of our term. Thank you.
Thank you, Mr. Chair. Could council or somebody just clarify what the amendment that the Delegate Rose remind us all what the amendment does?
Looking at it right now.
Thank you.
It says the amendment provides that the salary of the sheriff shall be $191,078.10 beginning in 2026 and $212,309 beginning in 2027. Doesn't say fiscal 26 or fiscal 27. It just says beginning in 2026.
Okay. Yes, I've got a letter here from our Board of County Commissioners supporting and asking for a favorable passage with those exact values.
Mr. Chair. Mr. Chair.
Delegate Erican, then.
Move the previous.
Well, okay, there are more people talking. Delegate Schmidt.
You can move it. You could, we had the same bill for Anne Arundel County. We passed it unanimously. I mean, and it's not for the current sheriff. It's for the next elected sheriff, is my understanding. Yeah, I understand. I know.
So just Delegate Boucher, my looking at this, it doesn't look like there would just be a couple days where the sheriff would receive $191,078.10. It would be all of 2026 under the bill as amended, and then it would go up again because the effective date, well.
When does his term end?
The term would end at the end of 26. So
212.
Yeah, the currently.
Section.
Sitting sheriff can't
2026.
under the Constitution. So if his term is like a delegation passage.
okay, so the argument is that because he can't receive a raise during his current existing term, that your point is that for that time between December 5th, 2026 and December 31st, his salary would increase to the 191 number, and then it would go up
Within 26 days. So this bill is a bit deceptive, and it's deceptive my constituents. My constituents are paying higher property tax. They're not getting raises. This is a 51% raise. This is a tough pill for my constituents to swallow. I love my sheriff. I think he deserves a lot of money, but I just don't think as a representative of my constituents or a fiscally conservative that this will float well with them.
All right, Delegate Munoz.
Thank you, Mr. Chair. So just to clarify, the Carroll County delegation supports this bill. This is a local bill that was passed out of the Carroll County delegation. Is that correct, Mr. Chair?
I have I have a letter from the Carroll County delegation, yes, supporting the bill as amended.
And so we're,
Well,
the
I have
commissioners
I have a
and the
letter.
delegation
I
support
have
this
a
bill as
delegation
amended.
letter. Do I have a delegation? I have a delegation letter. Yes. Saying it was unanimous on the 18th of January.
Okay, so this is a local bill that was voted out of delegation unanimously, and we here in judiciary are so kind that we support local courtesy.
I don't know if we're kind, but Delegate Boucher, and then I'll come to you, Frank. Delegate Boucher.
The bill was voted on unanimously, not the amendments. I was not even aware of these amendments until I read it in a newspaper 2 weeks ago. My colleagues in the Carroll County delegation never approached me about this amendment. And when I was confronted by the chairman of the delegation that the article that ran in the Carroll County Times was false information. And then she came in here and introduced that amendment. I was told that this amendment in the newspaper was false information, and that gets presented to this board and this committee in hearing.
Delegate Conway.
I was wondering, do we have a breakdown of the vote from the delegation, or we wouldn't have that?
Well, okay, so I'm going to tell the committee exactly what I have.
On the
What I
the
have
bill
is it's on the bill. It does not indicate that the bill was amended. It includes a vote that showed that Senators Reedy and West voted for it, and that the 4 delegates voted for it. But again, it does not indicate that the bill was amended.
I wasn't finished.
Yes, that's fine. I'm answering your first question. Go ahead.
Thank you, Mr. Chairman. I was wondering, since we're a little bit confused, could I use a hold on this?
If you would like to hold it, that would be fine. But it will give, but just to be clear of what I'm gonna do next, because I'll put it out on the record. I want everybody to understand. It doesn't give me any joy to get in the middle of an intra-delegation anything. It does not bring me any joy to do that, but I do. It's a fine point, but this doesn't say that it was amended. This says that the bill was clean. And that is a problem if then there's an amendment that's coming through. I don't have anything from the delegation, and maybe that's a fine point, and maybe they meant to do it. I don't know. But and if that's what they meant to do, fine. But before we move the bill, I want to make sure that that is in fact the case. And so we'll do that and we can bring it back. There are many people with lights on, so I'll go to Delegate Tomlinson since you're from Carroll County first, and then go from there.
So what is the debate at this point? I mean, as far as like what's not confirmed?
So what I would like to do is to talk to Delegate Rose, the chair of the Carroll County delegation, because normally what will happen, like with the last bill that we had with the city, the last bill from the city, it comes clearly saying that we supported the bill with the following amendments. This piece of paper does not say that, and that leaves me in a place where I need to find out what happened there. So I would like to find out what happened there, and then, because again, as was rightly pointed out by the ranking member, it's a local courtesy issue. I want to make sure we're doing that right, and I want to make sure that if the delegation supported it, they supported it, that's fine. It's just if there's a question about the amendment, then I need to address that. Delegate Grammer.
Bill's been held?
Yes. So we will come back to it early next week. The other part of this is I'm not sure where it is in the Senate, but we'll find out that part too. And again, don't want to get in the middle of it passed the Senate as amended. Okay, well, then we just need to, taking a breath is not
Today, I apologize.
That's fine.
I apologize.
I'm going to talk to Delegate Rose. I will do that today, and then we'll go from there. House Bill 1258, Delegate Embry, please. House Bill 1258.
Thank you.
So favorable in a second. There are no amendments. There. Delegate Embry has a bill here. Any questions about the bill? Sorry?
How many trees would this save?
How many trees will this save is a question. How many jobs will this lose? Ooh. Ooh. Okay. There's a favorable in a second. Okay, stop the whistling. All right, I mean, come on. Further discussion and cat calling. All right, the vice chair.
For the trees, yes.
Yeah, the Lorax votes yes. Munoz. Yes. Crutchfield. Yes. Carden. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Moon. Yes. Valentine. Yes. Conaway. Excused. Kaufman. Yes. Williams.
For the clients, yes.
All right. Okay.
The next one, can I have the same courtesy that Delegate Williams granted last week and we recorded it in?
I'll do that at the end. So I'm gonna do that at the end because otherwise I will lose my mind and I don't feel like doing that. Not just yet, a little later. Now in the thought you never would see this happen category, Delegate Chisholm, House Bill 1316. This went to subcommittee, I think, right?
Yeah, it did, but it's-
Oh, never mind. It's amended. What does the amendment do, Holly?
So the amendment, and holding over actions, the district court must order the summons for the tenant no later than the bill as drafted said 30 days, but the Maryland Judiciary requested that it be 45 days. And they were able to make that work. And then the second amendment says that it may be served by a process server. But as the bill is currently drafted, it says a licensed private detective agency. And so process server is more expansive.
There's a motion for the amendment. Is there a second?
Second.
All right. Any discussion on the amendment? Seeing none. All in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6. Anybody opposed? Amendment's adopted. We're on the bill as amended. Is there a motion on the bill as amended?
Second.
Motion for a favorable and a second. Any further discussion on the bill as amended? Seeing none. The vice chair?
Yes.
Yes. Munoz?
Yes.
Yes. Crutchfield? Yes. Carden? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Erican? I'm sorry? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon is up. Oh, he's back. Valentine? Yes. Conaway? Yes. Kaufman? Oh, and an Erican. I'm coming back around for that. And Williams?
Yes.
Yes. If you'd like to be added on, raise your hands. Munoz, Schmidt, Simmons, Crutchfield, Carden, Phillips, and Kaufman, Conaway, Pasteur. Don't see anybody else. Mark them on the side for you. Okay, now everybody, I know you saved your most difficult questions for this bill.
Yes.
There's a motion for a favorable.
Second.
And a second too? Oh, I guess we'll have to talk about it then some. Delegate Roberson's very first bill, everybody. I don't know why you're applauding now. He hadn't passed anything yet. Delegate Williams.
I have a lot of
I
questions,
do too.
Mr. Chair, about this bill. First, the newest member of the Prince, well, not the newest, but second newest member of the Prince George's County delegation, is bringing these bills about drunk driving
I know.
and points assessments. I just am really concerned as chair of the delegation, how this is going to affect the residents of Prince George's County. Delegate Roberson.
Can't even do it without smiling. The worst part of it, you can't even do it without smiling.
Anyway, I don't have any questions for the bill sponsor.
Anybody else not have questions? Okay.
So when, right now, what's the assessment? The assessment's 8 points
So for
an H and an I.
For the driving while impaired, for the first time, it would be 8. For the second time, it's 12. So for the bill as it's, there are no points assessed right now under the MVA. Right now, even though it's their second, this is the subsequent DUI, and there are no points assessed at all. So if you got your first driving while impaired, that normally carries 8. If you got a driving under the influence, that carries 12.
Right.
So what this says is first of all, there are no points listed at all. This says for a subsequent, it's 12 or 12. Basically makes both of them 12.
But
Your license is suspended anyway.
But right now, there is no points assessed.
There are no points assessed at all.
But your license is suspended with no points?
Your license is suspended administratively, so this just closes a loophole, a glaring
Well, what it
mistake
does is
in
it raises
someone's bill.
your insurance.
Yeah. It's,
Whereas just getting it suspended doesn't raise your insurance, but
just
having
getting it suspended doesn't raise your insurance, true, but I would say if you're getting convicted of your second DUI, you should get points like you would have before. That's so
why don't you have points assessed on your second one, but you do on your first?
So in the drafting of the legislation, that was perhaps one of the delegates down the road's very first bills that was perhaps suggested to her by a newer chair. It did not actually include the points in the I wouldn't say it was a mistake. I would say that it was perhaps an oversight that Delegate Roberson is fixing with this legislation. We're very happy that he's fixing this. Delegate Roberson is getting the bill on the floor. Delegate Moon. Now
Sorry,
you're
no,
good.
I just want to understand how this works. So if the bill kicks in, is this the case where the bill would actually kick in on a third offense? If you assume there's a
The second or
PBJ,
the third offense, yes. It's a subsequent offense.
but just in the real world of things, it's third offense.
Third, yes.
Okay, that's fine.
Yes,
Thank you.
That's right. All right, now that I've explained Delegate Roberson's bill. And I'm not. No, I'm really not. Okay, let's why don't we vote on it? The vice chair.
Well, no one did. Okay, yes.
Yes. Munoz.
Yes.
Yes. Crutchfield.
Absolutely. Thanks for fixing this.
Yes. Carden.
Yeah.
Yes. Embry. Yes. Pasteur. Yes. Now think about this, Tolles. Tolles. Oh. 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 Ooh. How does the senior delegate from the 25th district vote? Can't be contingent. Yes or no? Yes. All right. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Pay attention. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? Yes. Kaufman?
Yes.
Yes. Williams?
Yes.
Robertson? Yes. All right.
Can I change my vote?
No. That's a housing bill. That, all right, we have two that are withdrawn, three that are withdrawn. What's the third one?
One of yours, actually.
Oh, yeah, well, there's that. 693?
Yeah. 698. Yeah, it looks like a 3, but it's an 8. That's mine, but yours is 1346, same thing.
Oh, 698, so definitely not this one.
Yeah.
Okay, so 1346 and 1298. Is there a motion for an unfavorable withdrawn? Oh, she moved it, seconded. All right, all in favor of the unfavorable withdrawn, say aye. Anybody opposed? Sounds good. All right, that concludes the voting session of the House Judiciary Committee. Thank you all very much.
But
Wait, don't take us off yet. I'm sorry. Yeah, there were voting, oh boy.
Oh, there were people missing during votes.
There were people missing during votes. Were there any that were contested?
No.
I don't think there were. Just as a consent calendar for delegates, Moon, Kaufman, Pasteur, Munoz. That was it. And Delegate Schmidt missed one, but they were all unanimous votes.
Yes, yes.
Not all of them were, that's the thing. I don't think we can do that. All right, I need everybody to hold on just a minute. Let me do this. That was a hold.
You didn't have to file.
Oh,
Yeah.
we did, okay.
Yeah.
All right, I'm sorry, I missed one that has to be withdrawn. I didn't say it explicitly. Let me do this. House Bill 698 is unfavorable withdrawn. There's a motion for an unfavorable and a second. All in favor of unfavorable withdrawn, say aye. Okay, that one's unfavorable withdrawn. Good. All right, one moment, please. All right, not 290. Not that one. Not that one. Delegate Schmidt on House Bill 406, Delegate Simpson's bill that passed with 21 votes, nobody opposed. It was a bill on marriage, on confidential communications. All right, you are a yes. All right, that's fine. On 435. No.
580.
No. Yeah, on 592, delegates Munoz, Pasteur, and Moon were absent. Otherwise, it was unanimous with one excused. Motion to allow them to vote aye. So moved and seconded. All in favor, say aye. Opposed, nay. Motion carries. Okay. Same thing on 648. Munoz, Pasteur, Moon, all, everybody else voted aye. Allowing them all to vote aye. Is there a motion? So moved and seconded. All in favor, say aye. All right, yes, yes. And Kaufman. We'll add Kaufman too. That's the sense of the group. All right, so this one is 848. Munoz, Pasteur, Moon and Kaufman and Williams. All, can I have a motion to have them all vote yes? So moved and second. Okay, not Williams, just Kaufman, Moon, Pasteur, and Munoz. All in favor, say aye. Aye for Munoz, Pasteur, Moon, and Kaufman, not Williams. All right. 854, Munoz, Pasteur, and Moon and Kaufman. All in favor of letting them vote yes, say aye. Moved and second, there's all in favor, say aye. Anybody opposed? Let Munoz, Pasteur, Moon, and Kaufman. All right, 960, Munoz, Pasteur, Moon, and Kaufman, all in favor of letting them, or motion to let all of them vote aye. So moved and seconded, all in favor, say aye.
Aye.
All right, anybody opposed?
Yes.
The motion's adopted. Moon, Kaufman, Pasteur, and Munoz. 1034. Moon and Kaufman, Balber City Bill on the sheriff. All motion to allow them to vote yes. So moved and seconded. All in favor, say aye. Aye. Anybody opposed? No. All right. Held 1060. And then I think we were all back in regular programming. Thank you all very much. Have a good weekend.